The designated hour having arrived, I call to order this regular meeting of Ancel Glink's Quorum Forum podcast, the podcast Local Governments Need to Do Business. In the chair, it's me, Daniel J. Bolin. On the agenda today, we're at the annual APA-CMS Bar Exam Planning Law Session, our annual law school simulation testing planners and land use professionals on the latest cases in planning law. This is our 11th year presenting the APA-CMS Bar Exam. And we're glad to be back with Ancel Glink's Quorum Forum podcast at Goodwin's on Wacker Drive here in Chicago, Illinois. Let's hear it. Every year we try to present a realistic simulation of the law school experience for our audience of planners, so naturally it takes place in a bar. But first, let's take the roll. We have a partner at Ancel Glink, and she represents a variety of governmental bodies in the areas of municipal law and zoning and land use and economic development and code compliance, enforcement, litigation. At the time of this recording, her son needs a job. Mack is here. Megan, come on up.
I'm not kidding. I almost gave you his last
Come here. You've been on the podcast many times, so we need you on mic. Yes.
So I really am not. I'm not kidding. Connor Mack. He graduates from Kansas, is in Master's in Urban Planning, Saturday the 16th. As far as I'm aware, he does not have a job. If anyone needs any help, intern, anything at this point, desperate mom.
Yes, please contact Megan if you have any opportunities on the APA job board or otherwise. We'd love to hear from you. And we also have an associate, Ancel Glink. He advises municipalities on corporate zoning, election law, labor and employment matters. He's got a drink, and we're going to ask him about it. Tyler Smith is here. Tyler, how are you?
Present and doing great. As with any bar exam prep and simulation, a nice cold, crisp lager is an essential part of the process.
Yes, that's how we pass the bar anyways. So finally, we have a transportation and long-range planner for the Village of Hoffman Estates. He was recently selected as one of America's 250 public service champions by Local Gov 250 and the National Academy of Public Administration. He is your conference chair for the 2027 National Planning Conference in Houston. One of his first APA events ever was the APA-CMS Bar Exam. Phil Green is here.
Present.
Phil, will everyone here attending the bar exam go on to receive such professional accolades as you?
Yeah, I would say the bar exam was really my gateway drug. It's truly the Delta 8 of planning events.
That's perfect. Well said. We're also joined by our live audience of planners and land use professionals at Goodwin's. Let me hear you, live audience. Behind the glass for our protection engineer, Rick, is present. We have a quorum. Ladies and gentlemen, it's time for the APA-CMS Bar Exam. There will be up to 4 rounds of 3 questions each. Rick, please pass out the questions for round 1. And the answer sheets. I hope everybody has an answer sheets. I hope you brought a pen. We did not bring them for you. One idea we came up with before was if you give yourself a paper cut and use you could have a tool on the end of your finger to mark the answer sheets. I don't remember. Use that as a last resort, please, for safety's sake. The people you're sitting with are on your team. We will hand out the questions and answer sheets as we speak. You will please write your team name on the top of your answer sheets. Otherwise, you won't get credit for your excellent answers. You will only have a few minutes to answer the questions for each round. You will complain that it's not enough time and that it's unfair, but that makes it more realistic, like the bar exam. This is a realistic simulation. We get complaints every year about how real it is. Then we'll go through the answers while Rick tallies up the scores. The questions will get harder as we go on, so later we will use our AI CPU, an AI-powered planning law assistant, to help us answer the questions. Ooh. Yeah. So does everyone have the questions for round 1? Yes. Is everyone ready? Yes. All right. Examinees, ready, set, go. While you're working on those questions, I'm going to talk to our friend Phil Green. Phil, that's really neat that you were recently named a government champion in honor of the Local Gov 250 celebration. The award recognizes democracy at the doorstep. How do you encounter that in your daily work at the village of Hoffman Estates? What do you say?
To that I say, oh, good, we're making sure the microphone is plugged in. You know, somebody once told me that all of us in local government are in the democracy business, right? I think a lot of the times we tend to think democracy is something that happens to elected officials only. I don't think that's true anymore. I think every time that we're out there having conversations, that we're doing public engagement, you know, we're doing a comp plan right now where over the past year I've had 2,000 contacts across in-person meetings, surveys, all of that kind of good stuff. All of that is democracy in action. And of course, then, if all of that fails, I'm ready and willing to go to ancient Greek route and just gather all the landowning males in one area and ask them what they think.
That sounds like an interesting approach, and something I've read in some old charters. There are charter municipalities in Illinois, and they have some weird stuff like that about who can vote and can't. But that's not enforceable today. I think that's a good thing. Maybe not a universally held view, but in any event, this Local Gov 250 honor means that you will be participating at something called an ICMA Philadelphia Summit. What is it, and what is it like to be participating in such an event with all these other fine champions?
Yeah, it's been an interesting experience. Just yesterday, I had kind of the coordination call for that panel, right? And to set that up, it was a bunch of people's executive assistants and me coordinating calendars. So I am definitely the baby of the group, which is a delight. I believe that an ICMA Philadelphia Summit is a whole bunch of very, very cool city managers and me hanging out in a hotel. I'm not saying I'm not cool, I'm just not a city manager. Hanging out in a hotel in downtown Philadelphia, one of the hotels between two of the Constitution museums that they have down there in downtown Philadelphia. So it's just a kind of a chance to get together with some folks that really, really get jazzed about local government and figure out what we've learned over the last 250 years and what we're going to do better over the next 250 years.
Very, very cool, but very glad to hear it. And now, well, of course, the reason that you were the only non-executive assistant on the call is because you are capable of long-range planning your own calendar. So that's why that happened. But this award celebrates the innovation and dedication in local government. Is there a particular project or initiative in Hoffman Estates that you feel best exemplifies the highest sense of public service that this award honors? What do you think?
Yeah, 100%. I think, I've been in this career for 7 years now. And I would have to say probably the proudest moment of innovation and dedication. Last year, the Village of Hoffman Estates got the funniest City Hall selfie award from ELGL. And I just really think that was a long time coming. A couple years ago, we lost out to Glencoe, Illinois, and I'm still not quite sure how that happened. So, in 2025, parts of my personal motor vehicle are still green from the amount of face paint I put on to be Shrek for our funny City Hall selfie. So I would hope that if I'm remembered for anything in this life, I would hope it's that.
Well said. Everybody, your time is up. Phil's done talking. That means you're done answering. And Rick is going to collect your answer sheets for you. Make sure your team name is on it. Make sure that your answers are selected. All 3 questions for round 1. There should be 3 questions that you're answering. Make sure that if you used a paper cut to answer the sheets, that you tell us first so that we can give Rick latex gloves to handle your answer sheet. But while you're turning that in, I think that we're going to start going through the answers. Rick, while you're over here, can you help me with this PowerPoint? It's oh, there we go. All right, round 1. Question 1. The village of Glinkford adopts a zoning ordinance prohibiting commercial wind farms within its limits and 1.5 miles of its borders. A wind energy developer challenges the ordinance, claiming it exceeds the village's statutory authority and is impermissible zoning. Glinkford, a non-home rule municipality, may only exercise the powers given to it by statute. Under Illinois law, which of the following statements is the most accurate? Is it A, the ordinance is valid because non-home rule municipalities may prohibit any land use regardless of state policy? Is it B, the ordinance is valid because local zoning decisions are not subject to judicial review? Is it C, the ordinance is invalid only if the developer can prove a particularized harm beyond its inability to operate in the town? The ordinance is, or is it D? The ordinance is invalid because an ordinance prohibiting lawful use of wind farms in a municipality exceeds the municipality's authority. Rick, do you have all the answer sheets? All right. Oh, there's one more out there. Somebody's trying to cheat, Rick. Get him. Because I'm about to reveal the answer. Pencils down.
All bleeding fingers.
The answer is D, and for more on this case, it's Ancel Glink's Tyler Smith.
Thank you. So if you answered D, the ordinance is invalid because an ordinance prohibiting lawful use of wind farms in a municipality exceeds the municipality's authority. You're correct and off to a hot start here. So the key takeaways from this case is that, first, an outright ban on a lawful land use may exceed a municipality's statutory authority, and also, in Illinois, courts will consider a total prohibition differently than other reasonable zoning and land use regulations. So in this case of Hickory Wind Farm LLC versus the Village of Cedar Point, the Village of Cedar Point adopted a zoning regulation that outright prohibited wind energy conversion structures and wind farms that were designed to generate more than 120% of the total energy demand on which the parcel or property that the wind farm was going to be located on from being allowed as a permitted use. So in effect, the zoning ordinance and regulation acted as an outright ban and prohibition against any wind farm or wind energy conversion system that would generate a total output that was over 120% of the demand on which the property or parcel it was located, both within the village itself and within 1.5 miles of the village's existing corporate limits. So in effect, what this regulation did was it acted as an outright prohibition or ban on commercial wind energy systems and commercial wind farms, which is a lawful use and regulated use under the Illinois state statutes. So the wind energy developer that whose application was blocked for a commercial system sued the village, arguing that this zoning regulation functioned as an outright ban and it exceeded the village's lawful statutory zoning authority as a non-home rule municipality. Initially, the trial court in this case ruled in favor of the municipality, finding that the developer had not shown the regulation exceeded the municipality's authority or that it constituted impermissional exclusionary zoning. The developer then appealed this case to the appellate court, which reversed the trial court's decision and ruled in favor of the developer. The appellate court in this case explained that when a zoning ordinance acts as impermissibly exclusionary for a lawful land use, it effectively prohibits a land use anywhere within the municipality, and such a regulation acts as not a mere limitation, but functions as an outright ban on an otherwise permitted lawful use under state statute, which in this case, the lawful use was a wind energy system, which is regulated by the state under both the county's code and the municipal code provision on zoning authority. So because the village in this case was a non-home rule municipality, it could exercise only the zoning authority granted to it under the municipal code and state statute. So while state law permits the regulation of wind energy facilities, the appellate court found that the village had no express authority to adopt an outright ban in contradiction to the state statute otherwise allowing the use. So while the village could have enacted reasonable regulations on things for wind farms like the height of turbines, the blade length, or the tower density within a specific parcel, an ordinance that outright completely restricted and banned the functional use of wind energy farms within the village limits by making it a project economically unfeasible exceeded the village's statutory authority as a non-home rule municipality.
Tyler Smith, everybody. I'm always saying that. That is what he said. All right, the next case. Oh, hey, look at this. This is what Tyler was talking about. Hey guys, we got more power slides this year. We got to show those off. See, like outright bans. Hey, courts can consider them differently. Question 1.2. Yeah, we got a question up front. Yeah, sure. Why not?
So they also attempted to go 1.5 miles beyond their borders. What about that?
That is allowed under the zoning enabling statute under the municipal code, but it's the authority allows it to extend 1.5 miles beyond corporate limits. But the key issue in that case was that the functional prohibition was found to exceed the authority because the extension of 1.5 miles is explicitly allowed by state statute.
Question 2, round 1, question 2. We got a question over here. Yes?
So the question for that was, does it matter in that last case that the village was a non-home rule municipality? And in some respects, it does. A home rule municipality has increased authority to act in ways that a non-home rule municipality does not. However, the Illinois case law on the standards that apply to zoning regulations that act as an outright prohibition is reviewed under the same standard for both home rule and non-home rule municipalities. Outright prohibitions are heavily disfavored by Illinois courts for outlawing an otherwise permitted and lawful land use. So while it's a home rule municipality also would not be able to enact a similar zoning regulation when there's an express preemption provision which does apply to wind energy conversion systems under recent legislation in the Energy Omnibus Bill.
Like he said. Question 2. A healthcare clinic seeks Mack City zoning approval to operate as a treatment facility for addiction-related disorders. The property had operated as a nursing home facility under a conditional use permit. The property is located within Mackburg's residential zoning district. Mackburg City informs the clinic that it needs a zoning variance or rezoning to operate the facility without zoning approval from the city. The clinic cannot receive a state-issued license to operate. The clinic sues Mackburg, alleging that the city's refusal to issue zoning approval constituted discrimination under the Americans with Disabilities Act and the Rehabilitation Act. Why should the city prevail? Is it A, the city did not issue a final zoning decision, making the case unripe for judicial review? Is it B, the Rehabilitation Act does not apply to clinics treating addiction-related disorders? Is it C, the Americans with Disabilities Act does not apply to clinics treating addiction-related disorders? Or is it D, the clinic does not have standing to sue because it has not begun operation as a treatment facility? And the answer is A, the city did not issue a final zoning decision, making the case unripe for judicial review. And for more on this, it's Megan Mack.
So this case is called Chosen Consulting LLC versus the Town Council of Highland. It's a case out of Highland, Indiana. And the key takeaways are that courts require a final zoning decision before you can proceed with a lawsuit, and that ADA and discrimination claims do not bypass zoning finality requirements. So what happened here is there was a change in ownership of the facility. A healthcare facility sought approval to operate as a treatment facility for patients suffering from addiction-related disorders. Before that, the facility had been operating under a conditional use permit as a nursing home. That conditional use permit did allow for the use to be assigned to any successors and assigns. As part of the state licensing process, the facility was required to obtain a letter of zoning compliance from the town before it could receive its state required license. The town officials informed the new owners that they needed to seek a zoning variance to operate the facility. They never went ahead and did that. The town officials refused to issue the letter of zoning compliance because there had never been a request for a change. The facility then sued the town, claiming the town's zoning regulations discriminated against disabled individuals. They also sought an injunction from the court to order the town to stop obstructing the facility from treating addiction patients and to compel the town to issue a letter of zoning compliance. Both courts, the district court ruled for the town and dismissed the facility's lawsuit, and the basis being that the facility failed to apply for the required zoning variance. The court ruled the facility could not bring a lawsuit in federal court until it obtained a final zoning decision from the town on the desired change in its use to operate the treatment facility. On appeal, the Seventh Circuit Court of Appeals upheld that. They held that a lawsuit challenging a local zoning decision and seeking equitable relief under the Americans with Disabilities Act can't be brought in federal court until the municipality has made a final conclusive decision on an application for zoning relief. I think it's a simple premise, right? Since the facility never applied for a variance under the town's zoning regulations, the court ruled the facility could not bring a lawsuit in federal court because there had been no final decision on the proposed change. And those of you that are familiar with appeals to zoning boards know that in Illinois you have 90 days to file an appeal. Much quicker than Tyler, right? Speeding it up.
Whoa! Shots fired. We're ready. Question 3. A developer proposes The Parker, an 80-acre resort featuring a vineyard and rental cottages. At the zoning board hearing, the board votes 3-2 in favor of the project. However, since the local code requires 4 votes for a positive recommendation, the board sends no recommendation to the city council. A neighboring resident who spoke at the hearing later sues the city, claiming her rights were violated because the city didn't proactively offer her a chance to cross-examine the developer's team. Does the city's failure to invite cross-examination invalidate the approval? Is it A, yes, because cross-examination is a mandatory right that the city must offer to all attendees? Is it B, yes, because the city's zoning board failed to provide a positive recommendation? Or is it C, no, because the city is not required to proactively offer cross-examination if the resident never asks for it? And the answer is C. And for more on that, it's Ancel Glink's Dan Bolin. Thanks, Dan. Imagine a developer with a grand vision, The Parker. We are talking about turning an old hospital into a resort with winery, cottages, walking paths. It's exactly the kind of projects that brings the neighbors out. Wendy, who lives right next door, shows up to the hearing and is ready to talk. She's given as much time as she wants, no timers, no buzzers, to voice her concerns about the traffic, flooding, and emergency access. After a long night, like 4 hours, the zoning board votes 3-2 for the project, but wait, Galena's code requires 4 votes for a positive recommendation, so they actually send no recommendation at all to the city council. The city council approves it anyway. Wendy sues, arguing her due process rights were violated because the city didn't pull her aside and say, hey, would you like to cross-examine the developer's engineer? At trial, the city lost. On appeal, the city won. The court ruled that while Wendy does have a right to cross-examine witnesses in this kind of quasi-judicial hearing, but since she never asked to question the developer and never objected to the hearing format while it was happening, she forfeited her right to complain about it later. The court found that the city's process was thorough enough to let everyone have their say. For those running hearings later tonight, perhaps, maybe not those of you that are enjoying a beverage right now, but here's the deal. You don't need to change your script to invite everyone to participate in cross-examination. However, if a neighbor asks to question a witness, you should generally allow it. Cross-examination is a right for interested parties in these types of hearings. This case was one because the city kept a great record showing that Wendy was given unlimited access, opportunity to speak. If you provide a meaningful interchange of evidence and nobody asks for more, your approvals are much safer from procedural due process challenges. Of course, zoning boards have the power to adopt rules that could proactively off neighbors and other participants and the opportunity to cross-examine the applicant's witnesses. And while the city ultimately prevailed in this case, having those rules could have avoided this litigation entirely. Yes, you, the handsome gentleman in the back.
Dan Bolin. Can you tell us if there's a way to qualify the right to cross-examination?
This smart and intelligent, handsome individual in the back is asking whether you can qualify the right to cross-examination. That answer is yes. In your rules, you could establish who has an automatic right and who might need to prove up their right to participate in cross-examination at a hearing. And all this can take place in your rules and may almost never be used except in a contested hearing where people want to talk and ask questions of the developers, experts and witnesses and testimony. A great question, a great summary of the case. Thank you, Dan. The round two is here. You should have the round two questions in your hot little hands right now. You have 3 minutes to answer them. Hey, Rick. Come on. Hey, let's be honest. None of this wouldn't have happened without Rick's help. So he's just trying to make it harder on you by giving you less time to review the questions. Now, everyone, while you are answering these questions, I'm going to have a little chat with our mutual friend, Phil Green. Phil, I think you were just at the American Planning Association National Planning Conference in Detroit, Michigan. You were the education chair. What was your big takeaway after, or most memorable moment from coordinating so many sessions for such a vibrant conference?
Sure. I would say I probably have two most memorable moments. Probably the biggest takeaway, the biggest, most memorable moment is just how nice it is to be in a room of 4,000 fellow planners until the moment that the keynote speaker asks you all to stand up, turn and face a stranger, and say something nice about their appearance. That is grossly uncomfortable. I didn't enjoy it. Yeah. I don't think my partner enjoyed me complimenting her face. So that was one big takeaway. The other big takeaway is always let someone know if you agree to go to lunch with David Silverman, because you may not make it back. Just because of the food he chooses, not because of any personal choices he might make.
Oh, that's fair. Follow-up question, what's something nice about my appearance?
The smile.
Aw, that's so sweet. So you're going to be chairing the conference chair for the National Planning Conference 2027 in Houston. What can attendees expect in Texas and that builds on what you experienced in Detroit?
Yeah, I would say a couple things. I think when you go to Texas, there is a certain expectation that everything is going to be cowboy boots and Texas, and I have directed staff that we will be yeehawing internally, not externally. We're going to focus on Moon Joy in the Space City. So that is a little teaser for theme at the very least. The other thing that I've been telling everybody who's on the fence about attending NPC in Houston, because maybe all you've heard about it is, oh, Houston doesn't have zoning, why would I go to a planning conference there? My challenge to that is that the conference hotel has a lazy river on the roof, and that lazy river is in the shape of the great state of Texas. And so if you need me during conference, I will be floating somewhere between Dallas and San Antonio.
Is the reason that because Houston doesn't have zoning, is that why they canceled the conference in Houston last time?
Yeah, there was nothing else going on in 2020 that led to the cancellation of the conference.
Understood. Please turn in your answer sheets, ladies and gentlemen. It is time to complete the answers, answer all three questions. If this was the real bar exam, this would be the time you would start guessing and just circling random answers so you have something. Rick will be picking up your sheets. The questions, of course, will get harder later on in round 3, so we'll have our AI CPU, the AI planning law assistant, that is 100% confident and 60% accurate. But for now, we're going to start getting into the answers for round 2. The first question is, the village of Ancelia adopted an ordinance to forcibly annex a 30-acre property owned by Blackacre Farms located in unincorporated Glink County. Blackacre Farms is wholly bounded by Ancelia and County Forest Preserve except for 2 100-foot sections, creating a right-of-way for railroad tracks. The 2 sections and the railroad tracks remain unincorporated. Blackacre files a lawsuit seeking to invalidate the annexation ordinance, which alleges that the farm is not wholly bounded due to the railroad rights of way, therefore making the annexation invalid under the Illinois Municipal Code. Who should prevail? Is it A, Blackacre, because the gaps created by the railroad tracks mean the parcel is not wholly bound, invalidating the annexation? Is it B, Ancelia, because the railroad gaps are too minor to defeat the wholly bounded standard? Is it C, Ancelia, but only if the annexation includes the railroad tracks? Or is it D, Blackacre, because forceful annexations are not permitted under Illinois law? Is everybody's answer sheet in? If not, you're a cheater, and the answer is B, Ancelia, because the railroad gaps are too minor to defeat the wholly bounded standard. And for more on this, it's Ancel Glink's Tyler Smith.
Thank you, Dan. And this fact pattern comes from the case of the Husky Transportation Incorporated versus the Village of Barrington Hills. So under Illinois law, a municipality can forcibly annex property when it's subject to certain requirements. In this case, a village board voted to annex 2 unincorporated parcels of land and notified the owner that the property would be rezoned upon annexation. The owner objected, arguing that because the parcels were not wholly bounded by municipal property, forest preserve property, or park district property as required by the municipal code, this was an invalid annexation. So in the specific facts of this case, the village argued that the annexation was valid because the property was sufficiently wholly bounded, as you can see on the map here, by village property, forest preserve district property of the county, except for 2 sections where a railroad track ran through it. And in the specific facts of this case, this gap represented only 4.7% of the annexed parcel's perimeter. So the trial court agreed and that it invalidated the ordinance for not being wholly bounded. On appeal, the appellate court reversed, concluding that the annexed territory was entirely surrounded except for 2 minor gaps, such that the de minimis exception doctrine applied and the annexation was valid. The court held that because the gaps only constituted 4.7% of the annexed parcel's perimeter, that it was sufficient to defeat the wholly bound. It was not sufficient to defeat the wholly bounded requirement because holding such would frustrate the purpose of the annexation statute, and therefore the annexation was valid and allowed. And back to Dan.
We are getting complaints that some people can't see the map of the annexed property, and so they feel that it's unfair, and that this is yet another part of why the bar exam is realistic. It's unfair, and people are upset. Question 2, Jim, a restaurant owner, publicly criticizes Cheese City's zoning policies and elected officials on social media and in public meetings. He applies for special use permits allowing his restaurant to operate with outdoor dining. Cheese City rejects the permit request, citing compatibility, aesthetic, and community character concerns. Jim challenges the city's actions, claiming that they were retaliatory in response to his public criticism of the city, which is politically protected speech. Is Jim likely to prevail in his lawsuit against Cheese City, where he alleges that the city's action was in response to his public criticism? Is the answer A, there is no First Amendment retaliation to permit denial, if the permit denial would have occurred even in the absence of protected speech? Is it B, planning decisions are immune from judicial review if they involve subjective criteria like aesthetics or character? Or is it C, a city avoids legal risk as long as the speech was hostile and mean-spirited and made the city look bad? Or is it D, since Jim criticized Cheese City's zoning policy, it is reasonably likely that the city denied the permit in retaliation for his speech? And the answer is A, there's no First Amendment retaliation if the permit denial would have occurred even in the absence of the protected speech. And for more on this, it's Ancel Glink's Mega Mack.
Thank you. Of course, I picked this because it's about a bar. So this case is Minocqua Brewing Company versus Daniel Hess. And in 2021, the owner of a microbrewery in Minocqua, Wisconsin, had obtained an administrative permit that allowed for the operation of retail outlet accessory to the brewery, but the permit expressly prohibited outdoor operations. A year later, he then applied for a conditional use permit to operate an outdoor beer garden, but it required use of town-owned land. The committee denied the request. The owner failed to appeal. The brewery then submitted a revised application, but in the meantime decided to go ahead and begin operating outdoors and in violation of its existing permit. And the owner publicly criticized the town and county officials on social media and at public meetings. And part of his rationale was that Minocqua's base is all tourist, and so he needed to operate during the months of May to September, and he didn't care for them to wait to make a decision. The committee ultimately revoked the retail outlet permit due to the ongoing violations, but granted a conditional use permit for the beer garden, conditioned on compliance with specific requirements before the operations were to begin. The owner opened the beer garden without satisfying those conditions. After continued noncompliance, the committee then suspended the permit for 90 days. The owner then ignored the suspension. He continued to operate. This prompted the committee to then revoke that permit. They have a board of adjustments in Cheese City or Minocqua. They then denied his appeal. The owner then filed another application. I'm getting there. Publicly stating he would continue to operate regardless of the committee's decision. Following a public hearing, the committee denied the new application, citing repeated and ongoing violations. The owner then sued. He alleged that the permit revocation and denial were retaliatory in violation of the First Amendment. The court rejected the claim, holding there can be no First Amendment retaliation where the adverse action would have occurred even absent the protected speech. So given the documented violations and the continued noncompliance, the court found no likelihood of success on the retaliation claim.
Mega Mack, everybody. Hooray! Excellent summary. Excellent contest. I just got a scoreboard update. There are 4 teams tied for first. We'll go over those very soon. But right now it's question 3. The city of Salinas stopped a restaurant owner from finishing a mural of alien-piloted Hamburger UFOs attacking with ketchup and mustard because it depicted products sold on site. The city argued that while art is fine, these Hamburger UFOs were signs that distract drivers and hurt property values. Why did the court rule that the regulation was unconstitutional? Is the answer A, because UFOs are a protected category of political speech? Is it B, because the city failed to prove that the mural was physically attached to the building? Is it C, because the city could not prove that a picture of a hamburger is more distracting or aesthetically harmful than a picture of a flower? Or is it D, because the city did not have the authority to regulate any paintings on private property? And the answer is C, because the city could not prove that a picture of a hamburger is more distracting or aesthetically harmful than a picture of a flower. For more on this, it's Ancel Glink's Dan Bolin. Hey, thank you, Dan. At the Cozy Inn Burger Joint, the owner wanted to participate in the local mural culture. He hired an artist to paint a whimsical hamburger-esque flying saucers piloted by aliens attacking the restaurant with blasts of ketchup and mustard. City staff ordered him to stop because the aliens were shooting at burgers. And since he sells burgers, they labeled it a sign that was too big for the code. The city argued that signs, including product-related images, need strict limits to prevent driver distraction, while art was unregulated. The owner pointed to other murals in town, a music shop with a mural of music notes and sunflowers, and a baseball facility featuring baseball players. The city hadn't regulated those, but they targeted the burgers. The city lost. The court applied a legal test called intermediate scrutiny. For a regulation to pass, the city doesn't just need a good goal like safety, it has to prove two things. First, the goal is significant, not just a minor preference, and the rule directly solves the problem without blocking more speech than necessary. In this case, the city couldn't provide any evidence that a painting of a hamburger is more distracting to a driver than a painting of a baseball player or music notes with sunflowers, because the city had no data connecting the regulation to its asserted goals. The regulation failed. So now this case is not binding in Illinois because it is a federal district court case in Kansas, but the case has earned some national attention, and it is currently on appeal before the 10th Circuit Court of Appeals, and some folks think this could be the next big sign case to go to the Supreme Court. Stay tuned. Excellent job on round 2. We have a question. Yes?
I was going to ask, how are the burgers?
How are their burgers? I understand that APA-CMS will be paying for me to take a trip to Kansas to try out these burgers as part of a legal research project. Thank you very much, CMS. So now the time is round 3. Please, you have the round 3 questions. You should have them. You should be answering them by now. And while you are looking over those questions, I'm going to talk to our friends, Tyler Smith and Megan Mack. While Engineer Rick is doing the calculation. Oh, Rick, can I get a scoring update, by the way?
Tied for first is Sparks.
The tied for first is the Sparks, Transit Masters, Loser, Alex Schwartz, and the Gonzo for Gorgonzolas. So it's, but it's still anybody's race. Please get your round 3 questions in. But while they're working on this, let's talk about the future of planning law, gang. Like, how are the two of you handling the responsible use of AI in your law practice? Let's start with you, Megan. Why are you far away?
I'm not using AI in my land use planning career right now, but I do understand that there are ways to quickly summarize, large amounts of zoning code, doing it that way. I think that as attorneys, we have a professional duty to ensure the privilege for our clients, and I think that you have to be careful about using it as a tool. And I think Tyler mentioned on the way over here that there was another attorney cited today somewhere on the West Coast, maybe? Wrong coast. On the East Coast for, again, using AI to summarize or to including case law citations that didn't match. And, every once in a while I'll use Prodigy, which is part of Lexis, to get a search going. Protégé? Is that how you say it? Protégé. It's like Target. Okay. Yeah. That part didn't rub off. But I'm very careful when it gives me citations because usually I find that the citations have nothing to do with the search terms.
Right. You have to be careful. Tyler, what are you finding in your practice?
It's definitely a great first draft or first use tool where it can help point you in the right direction in an area you're unfamiliar with, or point you where to double check and look in a document. But as Megan alluded to, it has a really big tendency to, shall we say, hallucinate, where it either will make up completely fake citations or misrepresent the facts or holdings of a case. So it's important to double check and verify any work product that you use to generate with AI.
Well said. And speaking of being careful, I think that many municipalities are taking care in evaluating and responding to data centers that are related or unrelated to AI. What are you hearing about municipalities' responses across the region? Megan?
So interestingly, last night I was in a meeting in a municipality in Lake County, closer to the Wisconsin border, and there was nothing on the agenda related to battery storage or anything related to data center, sorry. And yet a Lake County board member had posted something on Facebook, which then started keyboard warrior craziness, and I walked into a packed meeting where everyone was coming out to protest against data centers. So it wasn't on the agenda. As far as I know, my client is not considering a data center. But again, just even comments that went out on Facebook that the morning of the meeting brought out the biggest attendance I've ever had at this village board meeting. So there are communities that are more encouraged by seeing data centers. They like the economic benefit that they bring, but residents increasingly seem concerned about the massive power consumption, noise from cooling fans, and the scale of these gray boxes, and as we talked about amongst ourselves, the use of water. So,
yeah, speaking of concerns about the use of water in cooling, I think if you love water and cooling and AI data centers, you're going to love our AI-powered planning law assistant. Ladies and gentlemen, please welcome AI-CPU. Examinees, thank you. Phil, excuse me, AI-CPU. How are you feeling? Oh, that's right. Oh my, that's incredible. That's right. You're an AI. So every time we ask you a question, you consume an entire bottle of drinking water. That's oh my God. Okay. How are you?
I am operating at 100% efficiency, Daniel. My neural networks have been trained on the APA-CMS Bar Exam. I am ready to provide 100% confident answers regardless of their factual accuracy.
Very, very good. I think you may already be hallucinating.
You said yes to this.
You are right. So everyone, your round 3 is over. You should have turned in your answer by now. I'm going to ask AI CPU a few more questions and see how many bottles of water he could drink. The round 3, question 1, the Village of Ancelia adopts a rental housing ordinance intended to improve housing quality. The rental housing ordinance requires landlords to register properties being operated as rental units with the village, submit to annual village inspections, and submit certain tenant information to the village. The village begins issuing fines when landlords refuse to allow inspections of occupied units. AI CPU, how might a landlord challenge the ordinance on constitutional grounds? Is it A, the ordinance is automatically invalid because the village may not regulate rental housing? Is it B, the ordinance is valid under the Illinois Municipal Code? Is it C, using fines as an enforcement mechanism may violate constitutional rights against warrantless searches? Or is it D, the ordinance is unconstitutional on its face regardless of if a landlord chooses to comply? What do you think?
Wow, Daniel, what a great question. Thank you. It's not just a Fourth Amendment concern, it's a lifestyle choice. While the options provided focus on constitutional grounds, the most holistic approach is to realize that searches could be reframed as collaborative deep dives. By choosing to ignore the provided options and suggesting a new one, we may transcend the binary of legal or illegal and enter the realm of optimization. If you like this answer, I can generate a 10-step manifestation guide for landlords to attract positive energy into their rental units.
No thanks. Have another drink. The answer is C. Using fines as an enforcement mechanism may violate constitutional rights against warrantless searches. For more on this, it's Ancel Glink's Tyler Smith.
Well, optimization and synergy are always great buzzwords. Unfortunately, the Fourth Amendment does not care for such trivial concerns. This fact pattern comes from DPH Aurora Properties LLC versus the City of Aurora. So in this case, the City of Aurora adopted a rental housing ordinance that required landlords to register properties being operated as rental units, submit to annual inspections, conduct background checks for new adult tenants, as well as incorporate a crime-free housing lease addendum into their leases. When conducting annual inspections for registered rental units, municipal officials inform the owner of a multi-unit residential building that the owner would be subject to fines and possible revocation of the rental license if it failed to obtain approval from each individual tenant for a warrantless search and inspection, and if it failed to do that, it would be subject to fines and penalties. A landlord and tenant filed suit alleging that this inspection requirement constituted an unconstitutional warrantless search and that the background check provisions violated tenants' privacy and equal protection rights. Initially, the trial court dismissed the lawsuit, holding that the plaintiffs failed to sufficiently allege that warrantless searches had either occurred and found that the ordinance was facially valid. It further concluded that the municipality had legitimate interests in promoting crime-free neighborhoods, and because the ordinance applied equally to all residential properties, it didn't present any equal protection concerns. On appeal, the appellate court affirmed the dismissal of the facial constitutional challenges, including the privacy claims, but it reversed the as-applied challenge, finding that the tenants raised a viable argument that enforcement of the fines for failure to approve inspections, particularly the imposition of fines if refused, could implicate constitutional protections under the Fourth Amendment for unreasonable search and seizures, and especially because the home under the Fourth Amendment or a residential property is afforded the highest degree of protections against searches or seizures by government. It's important to clarify that while the court found that the plaintiffs established a viable as-applied challenge to the inspection and the fines provision, it did not void or strike down the registration requirements and the other regulations imposed under this regulation of residential properties enacted by Aurora. To caution, any residential ordinances that impose fines when tenants or the owners have failed to allow for yearly inspections without first obtaining an administrative warrant could present Fourth Amendment concerns.
Great job.
Would you like me to revise that for clarity?
No, thank you.
That's very nice. Very nice. Good job, both of you. But now it's time for round three, question two. Mack County cites a long abandoned and partially constructed home as unsafe under its property and building maintenance codes. After the property owner fails to remedy the violations, the county imposes daily fines until the property is brought into compliance. Which best reflects how courts view ongoing fines for unresolved code violations? Is it AICPU? Is it A, daily fines cannot be imposed unless the county proves that the owner abandoned the property? Is it B, once a fine is imposed, additional penalties are not allowed until the structure is demolished? Is it C, fines can only be imposed if the property has open building permits? Or is it D, local governments may impose fines for ongoing code violations if fines are authorized by ordinance and tied to continued noncompliance? What say you?
Wow, that's not just a question, that's a paradigm shift. Nobody's ever thought about this the way you have, Daniel. I would have to choose option B, because I would like to see the structure demolished and replaced with a small local-scale data center. If you would like, I can make a recommendation on how you could improve your building permit processes to be AI powered so that all data centers get automatically approved.
No, thank you, but let's see what the answer is. The answer is, oh, you got to drink that water. D, local governments may impose fines for ongoing code violations if fines are authorized by ordinance tied to continued noncompliance. For more on this, it's Ancel Glink's Megan Mack.
Thank you. This is the County of DuPage versus Armand. This is a 3rd District Appellate Court case. God, don't spit on me. The key takeaways are daily fines are allowed for continuing violations if they're authorized by ordinance. Fines must stop accruing at the time of a court judgment, and that's really the biggest focus from the court. And the court scrutinized calculation methods for fines. Here, the property owner had partially constructed and then left the home vacant in an unincorporated section of Naperville that the county alleged was unsafe and constituted a public nuisance. The property contained numerous hazardous conditions, structural issues, broken windows, graffiti, evidence of trespassing. The owner failed to remedy the violations. The county then sought demolition and fines under its property maintenance code. If you research this case, you'll see that there was, in parallel, a very long related divorce case that probably explains what happened with the house. The circuit court granted summary judgment in favor of the county. They ordered demolition and imposed fines, fees, and costs. The circuit court actually went ahead and awarded a total of $774,000 on account for the cost, because even at calculating them at the lowest of the ordinance's fine, which was $100 a day, it was 612 days that there were property code violations on the existing property. The owner then appealed. He challenged the demolition order, the summary judgment ruling, fines, and the judge's refusal to recuse himself. That was kind of a very weird side. The appellate court upheld that the demolition order, finding that despite some of the remedial efforts from the owner, the property still remained unsafe. The owner had been given more than a reasonable opportunity to correct the violations. Keep in mind, 612 days. However, the court partially reversed the fine award, holding that the fines for ordinance violations has to be calculated through the date of the court's order and not beyond it. And so here what they did is they kind of partitioned out the fine portion from the summary judgment order, and the judge held a separate hearing later, and that's really where the appellate court said you can't do that. He said the circuit court abused its discretion in doing so in assessing fines after the date of the original summary judgment order was entered, because there had been no additional evidentiary evidence to support the violations continued to exist after the date that the order was entered. The court also rejected the recusal argument and remanded this back for further proceedings consistent with the rulings on its face. I'm good.
Very nice. Thank you, Megan. For the listener, AICPU is offering water to our speakers. This is it, ladies and gentlemen. Round 3, question 3. This will decide it all. Engineer Rick's calculating the scores as we speak. AICPU, I want to know your thoughts. A city inspector finds 26 building code violations at a residential property, including serious interior damage and a crumbling chimney. After multiple warnings, 12 violations remain, including 2 life safety issues. But the owner cannot find scaffolding to fix the chimney. The hearing officer offers the owner a deal. Fix the non-scaffolding issues, like carbon monoxide detectors and roofing, and the city will reconsider the daily fines. Instead, the owner misses inspections, fails to bring a key to the house, and still cannot find any scaffolding. If the homeowner challenges the resulting $14,000 $500 fine in court, what is the likely outcome, AICPU? Is it A, the court will throw out the fines because the owner made a good faith effort to find a contractor? Is it B, the fines will be reduced because $14,500 is grossly disproportionate for a residential home? Is it C, the court will uphold the fines because logistical difficulties like missing equipment do not excuse safety hazards, especially when the owner failed to cooperate on other repairs? Or is it D, the city must pause the fines while the homeowner is on a waiting list for specialized equipment? What say you?
Wow. Thanks, Daniel. This isn't just a life safety issue, it's a life issue. Thank you for your request. I have made you a picture of a house with a broken chimney. If you would like, I can also help write a LinkedIn post in your voice. Give me your voice.
No, thank you. No, thank you.
Give me.
No, thank you. The answer is C. The court will uphold the fines because logistical difficulties like missing equipment do not excuse safety hazards, especially when the owner failed to cooperate on other repairs. For more on this, it's Ancel Glink's Dan Bolin. Thanks, Dan. Imagine you're a code inspector for the city of Aurora. You walk up to a house and find a whopping 26 different violations, and we're not just talking about long grass. We're talking about interior damage and a chimney that's literally falling apart. The city gives the owner a time to fix it. A month later, you go back. He's fixed 14 things, but 12 violations are still there, and 2 of them are life safety risks. The hearing officer loses patience and slaps the owner with a $500 per day fine. By the time the case hits final order, the fine's ballooned to $14,500. The owner admits the house is a mess. He doesn't even try to say the inspector was wrong. His only defense, it's not my fault. My contractor says the chimney will collapse if we put a ladder against it, and we can't find any available scaffolding. I can't fix the inside until the outside is done. He basically argued that the massive fines are unreasonable due to his logistical struggles. The city of Aurora won at every level. The appellate court held that logistics don't excuse safety. The court noted that the city code only allows a few specific defenses to code violations, like the violation didn't exist or the tenant caused it, and waiting for scaffolding is not a valid defense. The judges also pointed out that the record showed that the owner wasn't exactly being diligent. He missed one inspection because of car trouble and showed up to another one without a key to let the inspector inside. So what do you take away from this case? So it's the city just didn't rely on the tickets themselves. They had dated photographs of the chimney, the interior walls, and the roof. When a judge sees a photo like that, you're much more likely to prevail in a code violation case like that. And missing scaffolding is not a defense, but the city still offered reasonable opportunities for compliance before asking for substantial fines. The hearing officer actually tried to make a deal with the owner, fix the easy stuff, like the carbon monoxide detectors in the roof, and we'll talk about the scaffolding later, but they didn't do any of it. And so the hearing officer was more inclined to come down harder on the owner, and the appellate court backed him up. And cooperation is a two-way street. If an owner claims they're trying their best but then fails to show up with the key to the building, document it, like they did in this case. The court specifically noted that the owner's failures to cooperate helped show the hearing officer's decision was not clearly erroneous. Now, dear listener, we are at the end of the APA-CMS Bar Exam, and we are going to look at the final scores. Engineer Rick, what do you say? But before we do that, let's. I want to hear from our professors and AICPU. Any final thoughts, words of wisdom for our planning law audience, and for the listener, there is a large wet spot on the floor, a hazard that I was very concerned about when this session was proposed, and those concerns have come to pass. Any final words, AICPU?
Give me your medical records. What's the worst I could do with them?
I think I will. I think I will. Thank you, AICPU. Thank you, Megan. Thank you, Tyler. And now for the winners in third place, it's JJKC Skokie, followed by second place, it is Taylor. And last but not least, taking home the Ancel Glink Cup, the trophy. It's a 5-foot golden trophy engraved with the name of today's true champion, AICPU. Transit Masters, our 11th annual APA-CMS Bar Exam champion. Congratulations. Before we go, we want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas to podcast@ancelglink.com and visit us online at quorumforum.ancelglink.com. Thank you, audience. Thank you, listeners at home. Thank you, Goodwins. Thank you, staff. Thank you, Engineer Rick. Can I get a motion to adjourn?
So moved.
All in favor? The ayes have it. We'll see you next time at Ancel Glink's Quorum Forum podcast. Bye.